Now coming to the next part of our discussion pertaining to executive power of the Union. We already discussed the executive power of the Union in accordance with Article 53, which says who is the sole repository of the executive power? It is the President. But it is not expected that the President will go out and do all the functions of the executive single-handedly or solely, though the power is vested in his hands. So Article 53 says that the President is empowered to entrust the functions of the executive, which is vested in his hands, in the hands of officers subordinate to him. So the extent of executive power of the Union, as we already discussed, is clarified under Article 73, which says that the extent of the executive power of the Union is coextensive with the lawmaking power of the Parliament, and if there is any other international agreement, to that extent the executive power of the Union extends. Now we will proceed ahead and discuss the various powers of the President, which is by far the most important concept of this module. When we look at the powers of the President, it can be classified under various heads. It can be classified into as follows. First and foremost, executive powers, which we have discussed by far. The second is legislative powers. The third being judicial powers. The fourth being military powers. The fifth being diplomatic powers. And last but not the least, the emergency powers of the President. Now, we will be discussing the executive powers of the President. The executive power of the President, as per Article 52 and 53, it vests in the President, but in accordance with Article 74, he is required to act in the aid and advice of the basis of the advice that is given by the Prime Minister and the Council of Ministers. What it means is that in no circumstance or in most of the circumstances, the President is not allowed to act independently. Of course, there are certain exceptions wherein there is the concept of discretionary power, wherein the President is expected to exercise his independent judgment and take decisions. But the general principle is that the functioning of the President and the exercise of the executive power ought to be in accordance with the aid and advice of the Prime Minister and the Council of Ministers. In the exercise of executive powers, the power to appoint also forms an integral part. So thus we can see that the President of India appoints various high constitutional offices and officers. The first being the Prime Minister and the Council of Ministers, who are appointed by the President. The Attorney General of India once again is appointed by the President. The Comptroller and Auditor General is also appointed by the President. So is the case for the Governor of the states, judges of the Supreme Court and the High Court, the Chief Election Commissioners, other election commissioners, as well as members of various constitutional commissions such as National Commission for Scheduled Castes, Scheduled Tribes and other backward classes. So the power to make appointments is an integral part of the executive power of the President. Last but not the least, when we speak of the concept of executive power, there is the power in the hands of the President to return the advice of the Council of Ministers once. As we've already discussed, the President is not permitted to act independently in most of the circumstances. However, it does not mean that he has no power to ask the Prime Minister and the Council of Ministers to reconsider. Under Article 74 Clause 1, there is a provision which enables the President to return the advice that is rendered to him by the Prime Minister and the Council of Ministers for reconsideration. However, this power to return for reconsideration is an exclusive one-time power. Hence, this power is sometimes referred to as one-time veto. That is, if the Prime Minister and the Council of Ministers resend the same advice, then this time the President has no other option but to agree and accept that decision or advice that is given to him. So for one time, there is a power in the hands of the president to ask the prime minister and the council of ministers to reconsider the decision or the advice that they have given him. So this is an important area wherein the president of India is acting in the exercise of his individual discretion, wherein he can take a judgment call whether or not a particular advice has to be accepted or not. If he rejects and it is resent to him, he has no other option but to agree to it the second time. Apart from this, the next important categorization that we speak of is what we call as the legislative powers of the president. What are the lawmaking powers of the president, or what is the linkage of the president with the Union Parliament? First and foremost, in terms of Article 3, the proviso, there is a power to make recommendation for a bill in respect of state reorganization. So Article 3 mandates that whenever there is going to be any change in the structural boundaries or the territorial length and breadth of the nation, in accordance with the constitutional provision under Article 3, there is a requirement for presidential recommendation. Without a presidential recommendation, no bill can be moved to reorganize or to alter the boundaries of the states in India. The second important legislative related power that the president has is that he has the power to appoint or nominate several members of the Lok Sabha as well as the Rajya Sabha, particularly members who are exemplary in various important fields such as service, education, culture, etc. So he nominates various persons and eminent personalities for the Rajya Sabha and the Lok Sabha in accordance with this provision under Article 80 Clause 3. Then he has the power to summon and prorogue the houses of the parliament. So whenever the houses of the parliament, be it the Lok Sabha or the Rajya Sabha, intend to meet or disperse, in both occasions there has to be a presidential order. So the power to call the house in session, that is the power to summon, and the power to terminate the proceedings after the conclusion of the session, that is what you call as the power to prorogue. Both of this is enjoyed or it's vested in the hands of the president in accordance with Article 85. More importantly, in connection with the Lok Sabha, the president has the power to dissolve. The power to dissolve the Lok Sabha vests in the hands of the president. So the president is empowered in the exercise of his legislative powers to recommend or to dissolve the Lok Sabha. Apart from this, he has a channel of communication with the parliament in accordance with Article 86 and 87, which enables him to send messages to the parliament, send over communication and interact through the official channel in accordance with Article 86 and Article 87, which speaks of presidential address in the parliament. That is, the President of India every year, the first session of every year, as well as after every new general election, that is for the first time a Lok Sabha sits, he addresses the parliament. And every year the first session of the houses of the parliament is addressed to by the president in accordance with Article 87. Last but not the least, he also has the power to call for a joint sitting. That is what you call as the power to merge both houses of the parliament in accordance with Article 108. Whenever the Lok Sabha and the Rajya Sabha are unable to come to a unanimity, consensus ad idem, they are unable to reconcile their differences, then this provision may be invoked in accordance with Article 108. Article 108 enables the president to call for a joint sitting of both houses of the parliament, wherein the Lok Sabha and the Rajya Sabha will be sitting commonly for a common session under a common hall, and they will settle the dispute or a bill that is subjected to a deadlock through a joint sitting. So the power to call for a joint sitting also rests in the hands of the president. Then comes the power to assent to bills. This is akin to the power of the Crown in England, who gives his final stamp of approval for legislations to become validly enacted laws. So as per Article 111, there is the power to assent to bills. Similarly, we have, as we have discussed in Article 74, wherein there is a power to return the advice of the Council of Ministers and the Prime Minister. Even in respect of ordinary bills, the President has what you call as a one-time veto. That is, he can return a bill which he disagrees with for reconsideration by the Parliament once. However, if the Parliament, that is the Lok Sabha and the Rajya Sabha, resend the same bill as is, then he is duty bound to assent to bills as resent. So this is the one-time veto that the President has in accordance with Article 111. Next comes, more importantly, the power to make ordinances, which is the legislative power of the President. Ordinance making power is dealt under Article 123 of the Constitution of India. Ordinance making power is once again an extraordinary power that is vested in the hands of the President, which enables him to make law in the absence of the Parliament. So whenever both houses of the Parliament, that is the Lok Sabha and the Rajya Sabha, are not in session, there is an emergency or there is an exigency or a necessity that a law be promulgated, an ordinance be promulgated, and it cannot be let to be waited until the Parliament reassembles. Then, in accordance with Article 123, the President is empowered to pass an ordinance, which is a substitute for parliamentary legislation, but subject to the rider or the condition that ordinances have an expiry date. They will have to be accepted by the Parliament when they reassemble. If the Parliament rejects, or after the completion of a specific time frame, if the Parliament does not act upon the ordinance, it fails. That is, as I said, ordinances are temporary legislations that are made by the President in the absence of the Lok Sabha and the Rajya Sabha to serve as a placeholder, to fill an emergency situation which will not be valid after a certain time frame. You would have heard about the horrendous 2013 Nirbhaya gang rape case. The mood of the nation was such that immediate deterrent measures had to be taken. But the Parliament was not in session, hence the President promulgated an emergency criminal law ordinance which imposed stricter severe penalties for persons involved in sexual offences. So this is a classic example of the utilization of the power to make ordinances in accordance with Article 123 of the Constitution. These are some of the important legislative powers that we have discussed in terms of the legislative powers of the President. When we speak of the judicial powers of the President, there is a callback to Article 60, wherein we saw that the oath of the President speaks about defending, preserving and protecting the Constitution. So it is his power and duty, the President's power and duty to defend, preserve and protect the Constitution under Article 60. Apart from this, an important judicial power or quasi-judicial power is vested in the hands of the President in accordance with Article 72. That is the pardoning power of the President. So ultimately, over and above the courts, after judgments are given, after appeals are exhausted, people who are languishing in prisons, who have been sentenced to life imprisonment, death or term imprisonment, they have a final option of approaching the President for mercy. What you and I will know as a mercy petition or a clemency petition. This is provided for under Article 72, wherein the President as a final dispenser of justice is able to pardon individuals in the exercise of pardoning power. Once again, under Article 72, pardoning power of the president, though vested in the hands of the president, is not actually enjoyed or performed by the president, but it is performed or it is decided by the Prime Minister and the Council of Ministers. So the pardoning power of the president is also exercised as per the aid and advice of the Prime Minister and the Council of Ministers. It is not an independent discretionary power that is vested in the hands of the president. Apart from this, he also appoints judicial officers under Article 124, that is the judges of the Supreme Court, and under Article 2 and 7, that is the judges of the High Court. The power to appoint judges of the High Court and the Supreme Court and to decide matters pertaining to seniority. This is vested in the hands of the president. Last but not the least, under Article 143 of the Constitution, there is the power to seek advisory opinion. Whenever a crucial matter of constitutional importance comes to the fore and the president or the government, union government is in a position of limbo, they may seek the advice through what you call as an advisory opinion of the Supreme Court. This is invoked in accordance with Article 143 of the Constitution, which is the advisory jurisdiction. Who invokes this provision? It is the President. With that, we wind up our discussion on judicial powers. We have next diplomatic powers of the President. So, as we have already discussed, it is the President who is the head of the state. As the head of the state, he has several diplomatic functions, responsibilities and powers. So the President of India represents India in international forums and in international matters, but primarily his function is ceremonial in nature. Being ceremonial in nature, it is the President who sends and receives diplomats. There is Indian diplomats to foreign embassies and foreign diplomats to Indian embassies and India. So this is the first and foremost diplomatic power. Apart from that, when we speak of diplomacy, there is an element of international law, international treaties and agreements. So in the exercise of diplomatic powers, as all the executive action is taken in the name of the president, then we can very clearly see that the powers of the president are such that it extends to what we call as making international treaties and agreements in his own name. So that being said, international treaties and agreements are also negotiated and concluded on behalf of the nation in the name of the president. Ultimately, these treaties have to be approved by the parliament. Next comes the question of military powers. What are military powers? Under Article 53 of the Constitution, it categorically tells that the President of India is the supreme commander of the armed forces. So in the exercise of his powers as the supreme commander of the armed forces, he is empowered to declare war, conclude peace, but on the aid and advice of the Prime Minister and the Council of Ministers. All top appointments of the Army, Navy and the Air Force, including the chief of these three branches, are done by the President. Military treaties and contracts are also made in the President's name. These are some of the most important functions of the President. Last but not the least, we have the emergency powers of the President. In a case of emergency, when the national security is threatened, when India is facing war, armed rebellion or external aggression, there may be a need for certain emergency measures being taken. This is dealt under the power to declare emergency, the emergency provisions of the Constitution. There are three types of emergency that you can see under the Indian Constitution. That is, in common parlance, referred to as national emergency, first and foremost under Article 352. That is, whenever there is armed rebellion, aggression or any other similar problem. The next is failure of constitutional machinery in accordance with Article 356. This is what we commonly refer to as state emergency. So in any particular state, there is a failure of constitutional machinery, law and order. The president is empowered to declare emergency in those respective states or regions of the states. Finally, we have the concept of financial emergency, when the financial stability or the credit of the nation is threatened. In that case, a financial emergency can be declared in accordance with Article 360. So these three types of emergency, the power to declare emergency under Article 352, 356 and 360 vests in the hands of the president, who will be exercising this power on the aid and advice of the cabinet headed by the Prime Minister. We will conclude this module with the last but very important provision pertaining to the removal of the president. As we've already discussed, when we speak of presidential removal, the phraseology that is used is impeachment. Article 56(2)(b) read with Article 61 deals with the procedure for impeachment of the president. The only and sole ground for which a president may be impeached is for violating the constitution. So the reasoning for impeachment can only be violation of constitution. How is the impeachment procedure done? Article 61 tells us. It tells us that a charge has to be preferred in either house of the parliament, that is the Lok Sabha or the Rajya Sabha. The first step is that there should be a 14-day notice that is backed by at least 1/4 of the members of the Lok Sabha or the Rajya Sabha. So a resolution which is backed by 1/4 of the members of either house of the parliament has to be given, which will serve as a 14-day notice. After the completion of the 14 days, the matter will be taken up in that concerned house and it will be decided. If the particular house wherein it is taken passes the impeachment motion with a 2/3 majority, so the majority that is required for impeaching the president is not a simple majority, it is a higher threshold of 2/3 majority. If the Lok Sabha or the Rajya Sabha, which has taken up the impeachment motion, passes the impeachment motion with a 2/3 majority, it is transmitted to the other house. The other house once again will investigate and deal with the matter and it will pass the matter with a 2/3 majority. If both houses of the parliament, the Lok Sabha and the Rajya Sabha, agree with a 2/3 majority that a person who is serving as the president has to be impeached for violation of the constitution, then that motion will be passed and that moment he loses his post as the president and he is thereby impeached. It is interesting and important to note that in the history of India, independent India, no person has been impeached. So with this, we bring our discussion on the position of the president, his role, powers and functions to an end. Thank you for your patient listening. Happy learning.